And now we must prepare. Hmm. Woza. Hmm. How are we doing today?
Mr. Whitaker, good to see you without a hat this time. How are you, sir?
Doing pretty good, Miss McDaniels. Yeah. I think one of the things they did not go over in the class was etiquette.
True, true. Well, maybe Huckabee needs to. Maybe he needs to add that to his course.
Yeah, I think that's probably one thing that would be good to add. There's quite a few different things, but in fact, with the things that I'm pushing for the firm, working on actually putting together an entire training program. So it's going to be interesting.
Good. Good for you. I actually am curious though. Shamel,
Hmm.
what happened to him?
Uh, he said something happened with his grandparents back home, and he's going to be gone for a few months.
I see.
So he's stepping away from the firm. So it's going to be me, Carter, Miss Victoria Ashmore, and then we got one other person that's wanting to come on, and somebody I talked to today that wants to be a paralegal. So it's slowly going, but I mean, with everything that happened with the butcher last week, it was hard to find time to sit down and write out policies and documentation. It was nuts.
Oh, absolutely. That's what happens when things happen. Time gets away from you. It's fleeting.
And it is. Frankly, there isn't enough of it to go around.
Just wish your client knew a little something about time, but nonetheless. Speaking of clients, Mr. Rugart hopefully will be arriving in the next 15 to 20, but he'll just help himself in if he ends up getting off the train.
Okay.
I imagine that Pepper should be here hopefully soon. He runs a little bit late sometimes, but he's a good man. Have you had the chance to meet him yet?
Mr. Rugart?
No, Pepper.
Oh, Pepper. No, I haven't met Pepper yet. I believe this will be my first encounter.
Oh, you'll like him. He's a good man. he's he's very wordy. I'll let you, just assess it yourself. But he's a very good man.
Wordy like Huckabee wordy or like hmm. Can't think of another example really.
Like I said, I'll let you make that diagnosis yourself. he, yeah, he tends to monopolize the conversation. But the best thing about it is, though, is he doesn't
Hey
monopolize it
there,
in a
Cass.
way that makes you feel it's monopolizing.
Mm-hmm.
It's kind of, I don't know. It's sounding worse, the more I say it, but it's in a good way. It's in a good complimentive.
Yeah, if there's like I haven't gotten the chance to meet all of the judges yet. Like I haven't seen how Henry approaches things yet, but with Longstreet, um, definitely have learned a lot about him because we
Yes.
had the Connor Olson trial, and that was interesting.
Hmm.
And then the last civil litigation, and with both of those, I got kind of the general concept that he's like a very very firm person, and
Hmm.
he's very by the book. So it's interesting to see how he approaches things.
Yes, he is very show me the evidence, don't show me emotion.
Mm-hmm.
Yes, he wants to know the cold hard facts, and if it can be interpreted correctly, then he's fine. He will agree with you.
Yeah, we tried to show emotion in the Connor Olson trial. That didn't go well.
No, they would never would.
But that's kind of the fun of it. We took that case knowing that it was an uphill battle. There was a lot of evidence against him. Um, we had a defense, but wasn't necessarily. the law wasn't being applied in the way we thought. We thought it was more of a accessory liability, or yeah, accessory liability charge, but
Mm.
it's more of just the wording on the attempted murder charge. So, there was that. We got to learn quite a bit more about how the court process goes. We got to learn about long streets. We got to learn what happens when you're only given 72 hours to get depositions from statement or from witnesses. Or actually, no, it was only 36 hours,
Mm-hmm.
and that was no, that was just miserable. I'm like, y'all had 2 weeks to notify the witnesses, and you wait 36 hours, and then they say, what was it, like 14 hours prior was when they were like, oh, we can't make it, and we're like, oh great, now we have to organize depositions, put it all together, send it to them, talk back and forth. Oh god,
Yep.
figure out how we're going to work it into our defense. That's just, in all honesty, I was kind of disgusted by that.
I want to backtrack for a second. I heard something. Maybe I had misheard it. So please clarify if you can.
Mm-hmm.
Wh- Who are you sending the depositions to?
We were sending it to the witnesses because they could not attend.
Oh, gotcha. Okay, so you were getting them. I see. So you were getting them to write their statements, and you were going to use that in the absence of them.
Right.
I see. Okay, I'm sorry. I thought you were indicating that you had given it to the prosecution, and I was like, "What are
Oh
you
no.
doing?"
We actually, and that was even more of the confusion because we thought that first the prosecution had to ask them questions with their deposition, then give that deposition to us, and then us add our questions to it, and then, uh, or rather, the witness responds to prosecution, then the deposition comes to us, then we add questions to it, then the deposition goes to the witness, and then back and forth until both sides are satisfied. We thought that's how it went, but then like 5 hours prior, the judge was just like, "No, just go ahead and y'all send individual depositions and just get started with it." I'm like, "This is what?
Yep.
What are we doing?"
So, yes, this is very much the state of Monroe where you are guilty until proven innocent. We do not have arraignments. Um, you know, we don't have quite a lot that happens here. It's unfortunately a rather new court system that's still learning, growing pains, if you will. I've I've been a prosecutor before, and I stepped away and then became a defense attorney for a moment again, and I was like, I this is why I prefer civil contractual law. Actually, I don't even like dealing with civil cases, but it's it's definitely an art form. But yes, state of Monroe, it's frustrating. So if you're going to continue in the defense portion, I wish you the best of luck because things will change constantly too.
I will say I do enjoy not doing defense stuff. It's rough.
Hmm.
And
It
I
is.
told Favish that I actually did not want to get into defense until I felt like I was prepared for it. But Connor was talking about his situation while I was up at the Olson Ranch, and we kind of dug into it a little bit, and then I went to go help Carter out, and that's when we started putting things together. Um, but that was just a mess. But we learned a lot from it, and
Good.
it's interesting your first day actually doing a trial because yeah, I felt what it was like to sweat on the inside but not on the outside.
Hmm.
Because I pretty much walked in there like, yeah, we're kind of screwed on this one.
Yeah, and unfortunately, you need to do your absolute best for your client. But there comes a point where if there's nothing that can be done, you ask
Yeah,
for a plea deal and hope that you don't have to go to trial in front of a lot of people, and have to deal with it. But it's also a good experience to have, you
it
know.
is.
If you've not practiced law outside of Monroe, to practice it here and to have that in court experience and to have that pressure, it's a beneficial thing to have.
You know what I've found interesting is the somber joy, the just subtle joy that I get whenever I'm helping somebody with their last will and testament. And I know that sounds kind of morbid, but it's actually a beautiful thing to be able to witness, what somebody's last wishes are and how much effort they really put into it. How many people do they care about? What are they leaving behind? And I enjoy helping people out with those things. It's it's got its own beauty to it.
Absolutely. One thing I wanted to make mention, and that I'm not seeing you do it. I'm seeing what is that guy's name? Is it Salerno?
Hmm.
And Amara. I'm not. I don't. John. I know him as John. um,
Hmm.
it's the creation of the wills. I don't know if Carter had shared with you when he was with us. Was very explicit about how wills are to be created per the law of Monroe, um, where it's basically one horse or one wagon, one gun, and the rest is to be approved by the state.
Right.
Money is a very fickle thing. People go, I'm leaving my money. No, that's not how that works. Because what will happen, and be wary of this when your clients do pass, and if you are the executor, um, that there are a lot of things that will not go to you, the people, respectively. What I mean by that is things will go missing or money will not be given.
All
So
right.
be very specific about request. Watch the wording that you put in, unless you have a template already. Um, it's very particular, and even then, as mentioned, it's up to the state whether or not they wish to grant that request,
Hmm.
not the person who died.
I try to make sure that if they say I want this item, I'm like, okay, does it have a specific title to it? Where is it?
Mhm.
Does it have a serial number on it? Always making sure to get those fine details so that the government
Yes.
knows exactly what they're trying to look for. What is the name of your horse or wagon? Um,
Yes.
things like that. As for money, there hasn't been anything expressed, so.
So let me put it to you this way. According to the state of Monroe, and you heard it yourself the other time when we were together with Mr. Longstreet, 1% of our population has over $1,000 in their bank. Now, I call that a lie. I'm sorry, but I think that's complete bullshit. But
I
if
do too.
that's what it is, then that's what it is. And the state has made that stance multiple times too. Then fine. I'll allow them to live in their delusion of it, but whatever. That being said, if we have someone that has $10,000, $15,000 in their bank, which is an exorbitant amount of money, sure. Um, Plus they have a home, plus they have wagons and horses and guns and all of that. This is someone who is very well off to do. And again, be careful with how you do things. Giving someone $500, I think, is pretty generous. I had a client, and actually, the reason why these rules weren't acted, I believe, was because of my client, Miss Honora Rose. Um, she had it wasn't a very large estate, but it was pretty substantial. She had two horses, she had some money, some jewelry, guns, etc. Um, but nothing totaled over like 5,000. I think it was like maybe like 40 something hundred, like 4,100. And the problem was the cash that she had, I think, was $1,300, 1,400, and that was withheld.
Hmm.
And it was decided upon that part of the money was to go to her brother. The other part I would retain as fees, um, or give it to who I see fit at the time, being the executor. So, like I said, 500 is probably more than substantial to give to one person, especially if they're getting a horse, a gun, etc. Because now that's adding more into their assets, if you see what I mean.
Hmm.
So, but either way. Oh, do you have the time?
Oh, it's about 9:30.
I see.
We're only waiting on Pepper and Rugart, right? Yeah.
Pepper mainly. Yeah, we can continue without Rugart. But Pepper is the man of the hour. I doubt it, but I wonder if he's in the actual. Let's go check the Again, I doubt it, but let's go look. Do
So
you mind
how
checking the
long?
judge's office?
Sure.
Oh, sorry, what were we saying?
I was gonna ask how long you've been practicing law.
Um, I have to think about that. At least 10 years.
Oh, okay.
Yeah, so not too bad. I'll meet you back here in just a minute.
All right.
Okay, no such luck. That's fine. We'll go wait in the front then. Yeah, it's been a little bit. I'm tired of it. Ugh,
You said you're tired of it?
interesting.
You said you're tired of it?
Oh, there you are. Just
Oh.
appeared out of nowhere.
I've been standing here trying to talk to you.
Were you? I'm sorry. My
It's
eyes.
okay.
I have to blink a couple of times. They aren't what they used to be, and I'm only in my 30s, if you can imagine it.
So am I. Oh, yeah, so you said you've already gotten tired of it?
Absolutely. I mean, like I said, I was in prosecution. And it's the civil side and the criminal side. Both have their. It's an adrenaline rush, sure, but it's also very mundane at times. Yes, as you mentioned, the satisfaction of helping people is great. Um, but I don't know. You know, Allie Pitbull, grabbed by the balls, McDaniels is I don't know.
You
I
definitely do
wouldn't.
come off as a pit bull, but at the end of the day, we both know we're just doing our best to defend our clients.
Absolutely, yes. Yeah, I try not to intimidate much. It's funny when you guys left. I was talking to Longstreet. He goes, I'm like, oh, well, they did good for them. And she was like, Miss McDaniels, I'm going to say this, and I hope you don't take too much offense. This little old tone there. He's like, you're a pit bull. I'm like, what? He goes, you're a pit bull, ma'am. He goes, you're not very nice to the new ones, are you? Like, not really. Take a case, you're going to deal with it, bud. But it's you know yes, there is definitely a line of professionalism, and then there's a line of being firm, or being overly aggressive, in a sense of it's not breaking your professional code. If I'm sitting there saying you're an asshole, that's definitely, what the hell are you, you know why are you talking to someone like that? Hello. um but Yeah, no, I try and be fair to people. I try and give what I can. It's like when we were discussing, the mediation. When I was telling you, well, no, there is no mediation. You denied my offer, so we're going to
Yeah, I'm
arbitration.
still getting used to all the because again, we didn't go through
That's
any
okay.
of this in class. Like,
Really? None of
yeah,
it? And all three? Okay. Well,
there was no discussion of like, okay, first you go through mediation and then there's arbitration. When we went into that last civil litigation, I had kind of no clue what exactly was going to happen. I mean, we went through the court process, but not the what do you call that meeting? Just an arbitration meeting or a pretrial meeting or?
sorry, can you repeat that again? My mind went racing for a second.
That's okay. So with with that meeting that we're about to have, is that called a arbitration meeting or is it a pretrial?
Great question. It's an arbitration. So
Okay.
there's no need to go to trial. I mean, if you feel, then by all means, definitely. But arbitration, what usually happens, so mediation is us sitting and talking, right? Formally
Hmm.
is basically is what it is. And we go, okay, this is what I want. This is what you want. So kind of like how we went the back and forth with, um, no, it's $50 or it's $100. No, she just ran by about not 15 minutes ago. Well, anyway, um, so it's a back and forth, an agreement, and then if we cannot agree, that's when the judge steps in, and they say okay, or the commissioner, whoever is assisting. But I believe here we only have judges, um, and says okay, well since neither of you can agree, these are the facts. This is what you're asking for. This is what I know to be the law, and this is the amount that you're getting. So something like, I call it, I'm not paying for your emotional boo boos. Pain and
Hmm.
suffering is not a thing here in the state.
Hmm.
There is for pain, and if you were to suffer with it, but emotional boo boos are not something that can be capitalized on.
Hmm.
Um, but maybe, who knows? You might make the difference today and change that with Pepper. um, but yes, it basically comes down to the kids can't agree, so mommy and daddy are going to step in and make the decision.
Yeah.
That's basically the best way to put it. Oh, there he is.
So with
Pepper,
the
is that you?
um, is it the fella on the other side of the fence?
That might be him. I'm seeing him from the back, but hmm.
So how nasty can divorces get?
Oh, I had one. So I had one. This is before I moved to the state, uh, where it was supposed to be amiable. Okay, he didn't want a divorce. She did. He was already seeing someone else. She was seeing someone else. She had a home in her name, and they had a baby together.
Hmm.
He denounced the child and said it was not his. Anyway, so he put nothing towards the marriage. Essentially, nothing financially, that is, or monetarily, I should say. He tried to get his attorney, which was what my boyfriend was at the time, to countersue, um, for the home. Basically, their whole stance was, "We want the house, we want the house," and I'm like, "Well, no, you aren't getting shit because we have the paperwork for everything. We have the deed, we have." Um, the bank statements that show she's paid for everything. You don't get a fucking dime because he was a sheriff and he made his own money. So that was the agreement that they had: is this is my money, that's your money. If you want to contribute, great. Um, but it can be pretty nasty. That I mean, you can have people drag it out for months. Um, I mean, look at Judge Henry. Here that's a great example. Judge Lafayette Cornwall, him and his wife Lucy, they're still going at it. you know he First there
Really?
was an agreement. I don't know if you've looked at the newspaper and saw the documents there, but apparently they're still going through it. They've yet to agree, though they had an agreement with Mr. Quinn, and he thought everything was kosher, and then come to find out, you know Lafayette says, well, no, I'm not happy with that after all. I'm like, hello, like, did we not just spend however long they spent negotiating? um Yeah,
Yeah,
it can absolutely happen like that.
I imagine I'm gonna be going back and forth with the state for a bit for there's a probate I've got coming up for Valentin Ramirez's widow. He didn't leave a last will and testament, and they have a fully paid off house that he had.
Well, then it
And
goes back to
so,
the state.
well, I've been talking with the judges, and what we're going to try and
Hmm.
do is argue based off of, kind of, it may have not been law, but it's also always been an ancient right that the widow receives um, some of the things that were left behind by the husband. because, or I
Well,
can't
sure.
remember the
The
proper
spouse, the
wording
spouse
for it.
is the spouse essentially. So you're
Hmm.
looking at it as the spouse will speak for the spouse in the case of they're one and the same. Is how we would look
Right.
at it. Okay, I'm following.
So we're gonna try and argue that because there's no real precedent set right now. And going to try and push that as hard as I can to try and set a precedent that this could be done, that it should be done, because it's it's right by the citizens. Now, they did say even if they do approve it, if it goes to real estate, they have the choice of accepting it or not. So, but at the same time, from my understanding, according to real estate office, if a property was paid off, they have no say in what happens to it.
Who
It
told you
is,
that?
I believe it was Miss Danes.
Unfortunately, I don't believe that's correct. And I may be incorrect in that because I have property that's fully paid off. But from
Hmm.
my understanding was, and this may be because I live out in New Austin, my business is in New Austin, but they have the right to, if you were to pass or something was to happen, they have the right to reclaim it. So if I'm gone and I'm presumed dead, they have the right to reclaim the property
Hmm.
unless it's, I'm proven dead, I have a will, and it goes to someone. Um, so I don't know. That is a good question.
Have
That's definitely
you
a good question to pose.
have you dived into the pool of business law at all?
Mhm. I have.
So, I mean, that's one thing that I'm definitely going to
Is
have
that
to
a gunshot?
look into. I didn't hear anything.
Oh, okay. Maybe it's just. Hmm.
But,
Maybe it was a
but
door closing, and I just. Anyway, sorry. Go ahead. What were you saying?
that's one thing I've got to look into because I mean, you've got lawyers that specialize in different things for different reasons. And, business law, we've looked at civil law, we've looked at criminal law, but as far as business law goes, ain't nobody got a clue. So
Yeah,
I'm sure that's a whole different ball game this day and age.
it is. So my specialty is run in real estate contract business. Um, the kind of family. It's something that I touched upon just because obviously with divorces, um, it was kind of necessary and for wills. But yes, so again, so going back to the state of Monroe, they do things very interestingly. So the REO is a sect of the state. Okay, they are privatized, but they're also state owned. Think of it, so think of it kind of like a prison. You know, you have it's privatized, but it's owned. Sorry, let me flip that. It's you get what I'm saying, I think, right? Do you catch what I'm saying?
Yeah.
It's a two-way playing field, from my understanding. Now, I may be wrong, but from what I knew about REO, what I've learned is it is and it isn't. Um, so it's
See, I mean, here's one of the things that, has me really curious. There's nothing in our Constitution, Bill of Rights, or anything like that that gives real estate office the jurisdiction and authority that they have.
nope, but that's Monroe for you.
Hmm.
It's basically I have the nicer, cooler toy, and you don't. Nanny nanny boo boo. I'm sorry to say it different, but that's how it is here. It literally is. It's this is my house, my rules.
uh, yeah, that is how things feel sometimes. I mean,
Yeah.
just like with the wills, we're set to a guideline of they're allowed to leave behind belongings and finances within reasonable means. That can mean anything. That
Yep.
is a absolute blanket,
Yep.
completely open for discretion. You're just kind of like, I don't know what to tell you. You can write stuff down here, but it might not happen.
That's literally what I tell my clients. I said we can request it, but it what I would tell them is if you think you're gonna die, throw all your shit on your horse and give it to the person you want to go to. Just preemptively, buy yourself a mule. If you're feeling a little sick, just get your affairs in order. A will, to be honest, is only good for real estate, really.
Yeah.
Anything past that, it's not worth it unless you are shot down dead one day, which is unfortunate. Um, but yeah, no, it's honestly sometimes it's not worth it to do it. I do have a question. I want to get back to Mr. Amaro. So, did they have a marriage certificate? Were they lawfully married?
Wait, for who? Oh, Romero. Yes, they were. They were actually married, I think, like 5 or 6 days prior.
5 or 6 days prior to him
Mm-hmm.
dying?
Mm-hmm.
Oh, that's gonna be hard to prove, darling. That's not like someone who's been with their partner for a very long time. That's gonna be hard for you. So
Yeah.
you need to stand firm on that and not waver, um, especially because there's no will there. So you're gonna have to prove that
Oh,
they had a
it's
long established relationship, and the marriage part was only just paper.
so I'm trying to remember when Romero passed.
It's about a week and a half ago, 2 weeks ago.
Mm,
Has it been that long?
it really has, hadn't it? Hmm. Let me take a look.
I'll tell you what. While you do that, I need to just close my eyes for a quick moment, and then just meditate, if you will. I'll be right back. Okay, you think about that one.
Okay. Like me and her are having a really friendly conversation right now, but I'm not sure if we're gonna be talking after this this litigation because this deposition is nasty. Yeah, Romero is really dead. I can't even remember when he passed away. Oh, but it's been a minute. Hmm. I really wish they would
Okay,
do death
terribly sorry about
certificates and
that.
stuff.
Whew.
Oh, that's all right. You know, as far as like medical records and stuff go, they're public, but it doesn't seem like anybody even does death certificates. No telling when somebody died.
True that. Um, yeah. So one thing I like about the state is that arrest, uh, medical, that's about it. Are the two ones that are open to the public.
Well,
Unless
from
they're sealed.
from what I'm told, arrest records are private.
They are not.
Really?
Really. If
Why do
anyone
they give
tells
me
you
so much?
otherwise, they're
Why
an
do they give me so
asshole.
much hassle every time I go to ask for an arrest report? They're like, okay, well, who are you?
Well, I mean that's fair to ask, but
True.
to identify yourself. But no, they have to hand it over. And if they don't, that's fine. You go, okay, you know what? That's perfectly fine. I'll ask someone else then. I know they're trying to make it a policy that you have to show your bar license. Um, Paralegals unfortunately don't have a bar license. They can, I believe, be given an identification. But there's no like serial number that is attached to that, a license number, if you will.
Mm-hmm.
So I don't know what Lafayette's going to be doing about that. And I had reached out to him, but I think my telegram went to someone else.
Uh-oh.
So I think there's another person who shares his telegram, which is rather awkward.
That is a little awkward. I wouldn't be very comfortable with that.
I'm surprised it's allowed.
I didn't know it was.
Yeah, I wasn't. Yeah, I thought that the registration service would have changed that. So,
Mm-hmm.
hello.
No.
Howdy.
What is this? Roy Evans. Roy Evans shot me. Hello, Felix.
Howdy. How are you doing today?
Oh, been better. How you guys doing?
Could say the same.
What do you mean?
Been better.
Oh yeah.
It's been a long, exhausting week. Well, at least the past
Why?
week, yes.
Is that?
Oh, well, there's been the butcher. There's been quite a few different gangs who have been causing a muck in roads and desecrating Grace Collins's grave. One of them shot my blacksmith the other day, who is also a lawman. And also good. Yep.
Yeah.
Yeah, there's a lot of different things that have just been going on the past week.
Well, that is absolutely terrible, Felix. So yeah.
What about for you?
Bye.
He's unhinged.
That's who was that?
That's Sharp.
Oh,
Mm-hmm.
I didn't even recognize him.
Yeah, he's unhinged. And they're
Yeah.
allowing him to remain a marshal still, which is beyond me. I don't know.
All right. Well, at least he's showering now.
Yes. Well, I believe it's been over some time since Mr. Pepper should have arrived. I'm rather worried now.
I'm sure he's just still stuck on the train.
curious if I can ask you, and then you're welcome to, to say you would rather discuss it inside. What does Pierce think he's going to get out of this, truly?
Well,
Or what is he trying to get, honestly? Because people will throw numbers out there like I did with Reagan. I threw $1,000. I'm not going to get $1,000. I'm not stupid. It's just to kind of make it be noticed. So I'm just curious. He was offered an apology. He was offered his money back. The poor guy was, Mr. Rugart was kidnapped. I'm just sitting here thinking, they're going to understand. You want things done. But being realistic, I'm curious.
So initially, he started off saying he wanted 1,000. Now, at the same time, in my deposition statement, it's referencing a lower number. But it's got multiple factors in it. It doesn't necessarily account for emotional stress or emotional pain. More of time that he spent. It accounts for the refund, then the cost of retaining counsel, and there's one other that would have to be something that comes up when we discuss what we're going to discuss in there.
Oh, that's fine. I mean, I was looking at you saw my remarks. I was looking at the breakdown, and I'm like, who the hell thinks, first of all, they send $500 in telegrams? I had to look at it again for a minute, and I'm like, what is this man talking about? I think it was like, maybe he's missing the decimal point. Maybe he meant like $5 in telegrams, and you were itemizing it. And then I look again, and I'm like, I have one of my paralegals look. I'm like, am I reading this correct? Am I just getting old? Like, do I need glasses? What's happening? And I was like, 500. Wow, awesome.
Yeah.
And so, yeah, it was just curious to me.
That was actually
where these numbers were coming from.
I believe that was just prior to the first civil litigation that we sat down with y'all with. I think that was just prior, so he didn't really know what he was walking into when they first set up everything with the case. As far as what could be applied, what you should look for, what kind of evidence you need to have, different things like that. So, it's definitely something that whenever I was writing the deposition statement, that I was like, okay, we need to change that number. Now, at the same time, I will say, it does aim high on one point because I expect it to be reduced. The judge is going to decide what's fair. And we'll just see what the outcome is.
Yeah.
Trying to make sure that everything's accounted for. Like I said, it's nothing personal towards y'all. Just doing my best to defend the client.
Oh, absolutely. Hello,
ladies and gentlemen. Hello.
Howdy.
I thought that was you.
It is.
Well,
Is everyone else here?
No, I believe Wolf should momentarily join us. I'm not sure about Mr. Pierce, though.
I don't believe Mr. Pierce is going to make it.
Who is
All
that?
right, that's all right.
Oh, wait, that is my Longstreet. Hello,
Perfect.
Mr. Longstreet. How are you, Chief Justice?
If you all are ready to begin, then we can. Is the other party's attorney here?
He's right
Right here.
Oh, this fella. All right. If
Yeah.
we're ready to begin, then we'll go over to the courtroom.
Alrighty.
I wanted to give Chief Justice here something. I should have
sure,
given
go
him
ahead,
last time.
feel
I
free.
apologize. If you don't mind, I'll meet you inside.
Okay.
Oh, that sounds great. By the way, Arthur, it's good to see you.
Yes, it's been a long time, Mr. Pepper.
I know it has. I'm very, very overjoyed to take a gaze upon your very, very, very handsome mustache. I like what you've done with it.
Yes, I appreciate that.
Alrighty, just join me when you all are ready.
So how's your day been, Judge Pepper?
It's been all right. It's been all right. So, are you ready? Are you ready to go to trial, counselor?
Yes, sir.
Alrighty, then we'll get ready to rock and roll then.
Oh, wait. Are we supposed to do it in here, or is...
Yeah, we'll be doing it in here. Yeah, that's perfectly fine.
Okay. The last time we did a arbitration, it was in a... What do you call it? Like a meeting room.
Yeah, this is a little bit more informal than a proper trial, but we'll be doing it in here.
Okay. Okay.
I wasn't aware we were doing it in here. More
I know.
formal than I thought.
I thought to myself that I might have to go out there and let you know that we were going to be doing it in here.
That's fine. No, I saw you guys go around the corner when I was
Yes,
talking
yes.
to Longstreet. So
No, that's perfectly fine. Get yourselves comfortable. First, I would like to hear from the plaintiff. When we came here, this arbitration is going to work a little informally because we're here kind of for a preliminary hearing. This is going to be kind of to determine if we need to go to full trial, call witnesses, and the whole shebang. So both parties will have a chance to read me their brief of their case and then discuss some of the arguments behind their case before we move to a trial proper, where we'll be calling witnesses and the whole like. So I would like to let you all take a few moments to get collected, and then when the plaintiff's attorney is ready, they may begin, and we'll get the plaintiff's attorney to speak first. So let me know
Mr.
when you're
Pepper,
both ready.
would you
yes, sir.
please speak up?
Oh, quite sorry. I was speaking very quietly. Sorry, ladies and gentlemen.
That's all right.
All right.
perfectly fine.
But yes. You have a question?
All right, so... Oh, go ahead. Sorry.
Well, I was going to say, if I may, and I'm not sure if Mr. Whitaker's on the same page as I am. We're here simply just for arbitration to get this finalized. I don't believe either of us have an interest in going to trial and dragging this out longer than it needs to be. So we're simply here to get a final decision on
A disputed matter. Okay.
a disputed matter. Exactly. Yeah.
Yes.
So I don't think this needs to go any further than tonight.
Probably.
I don't know if Mr. Whitaker, obviously, if you feel otherwise, then I mean.
No, I feel this is something that could be decided tonight.
Okay. If the plaintiff's attorney would like to go ahead and lay out their case brief and disposition very quickly, and then we can move from there. So you can begin now. Go ahead and give me your disposition. Explain in the best you can why your case has validity and why I should rule in your favor.
All right, so my client, Jaeger Pierce, sought legal assistance on the 24th of February. He arranged with the defendant to file a change of name and marriage dissolution petition for the fee of $175. At this time, he was unaware that the defendant wasn't a lawyer, but a paralegal, as the defendant announced himself as a senior partner of the firm. Exhibit A, this shows the plaintiff reaching out to the defendant and the defendant responding that he was willing to arrange a meeting to provide services. The last telegram is on March 3rd of 1899 at 10:29 Pacific Standard Time, stating that there was an accident between the time frame of February 4th and March 3rd, and the paperwork had not been completed nor filed as shown by the courts. On March 6th, my client contacted Favis Schimmel for counsel concerning the situation. After the discussion, Mr. Pierce decided to terminate all legal services and contracts with Mr. Rugart, stating that he would like a refund as the documents haven't been submitted before the courts. He requested this via telegram, as shown in Exhibit B at 1:50 Pacific Time. Plaintiff reached out to the defendant, stating that he would like to terminate all contracts with the defendant's services as they had not been rendered since February 24th, and that he would like to meet to settle it. In Exhibit B, you'll find a second telegram. We show evidence that the defendant stated that they filed the paperwork already. This was stated on March 7th, 1899 at 11:05 Pacific Time. Court records show that not only was it not filed by the defendant himself, but Tom Smith filed at 12:40 Pacific Time. So not only has our client had to wait 11 days and seek out separate counsel, but now they've had documents submitted against their wishes under the deception that they had already been filed. The defendant also claimed to have lost their telegram number, still seeing as how they could submit the document without further contacting my client about the requirements to file the paperwork. This statement holds no relevance as to why services had not been rendered. Not only is this fraudulent, but it is downright an abuse of the defendant's privilege and legal right to represent himself. Legal right. Seems I have confused myself in this.
That's okay. It's okay. Take your time.
Okay. Oh, now I see where I confused myself. Yes. Downright an abuse of the defendant's privilege. The legal right to represent himself as a paralegal to render services that involve filing and notarizing documents. The defendant's privilege should be held with the utmost respect and honesty, as people's secrets, livelihood, and overall well-being could rely on his services. This is why the Bar Association has rules of professional conduct that it does. In this situation, the defendant has violated the Bar Association rules of conduct in multiple areas. Item 3 states lawyers are officers of the legal system. Thus, they must ensure any documentation filed is done so in good faith. This was violated as our client chose to terminate services before submitting the documents. Item 16 states a lawyer or law firm shall not violate or attempt to violate the rules of professional conduct, knowingly assist or induce others to do so, or to do so through the facts of another. And then it also states that they may not engage in illegal conduct that adversely reflects on a lawyer's honesty, trustworthiness, or fitness as a lawyer. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. While these sections apply to lawyers, they also apply to a law firm. At the same time, item 3 specifies a lawyer must file. It is to be believed that the responsible party filing paperwork must file with the same level of accountability and responsibility. Without this being applied to the situation, no repercussions will happen to paralegals who decide to file false documents, collect false documents, or any other professional or dishonest actions that could arise from such a privilege, leaving no relief from any defendants now and in the future. Under item 16, you will find that it states this applies to a lawyer or law firm. In addition, it states that they may not violate or attempt to violate rules of professional conduct, knowingly assist in inducing so, and engage in conduct involving dishonesty, fraud, deceit, and misrepresentation. Not only was there a delay to something that had happened on the defendant's end, but the defendant could have assigned another firm member to handle it, but instead it was left in wait for almost 2 weeks. When the client wished to utilize the services no longer, he was not only refused a refund, he was lied to. Then, like the defendant should have done in the first place, another firm member submitted the filing an hour and 35 minutes later. This service was the defendant's responsibility, which they chose to take on when assigned to render the service. Furthermore, the deception is furthered by the deception given in Exhibit B, where the defendant states that they had sent someone to find my client and get his telegram number. Whereas in Exhibit C, where you can see the statement taken from Olson Ranch in Valentine, where multiple witnesses stated that no Tom Smith nor anyone else has come to find my client. They stated that they could not get in touch, but again, as covered earlier, this did not stop Rugart from filing the paperwork. In Exhibit D, the defendant claimed that his paperwork would be filed in 30 minutes to an hour. The client was then told 2 days later it would be filed. Our client has repeatedly had to reach out to the defendant, where he was given false promises and assurances that things were moving forward. This caused our client undue stress and significantly impeded his wishes. As the name Olson tarnished his reputation as a lawman. While initially our client wanted to ask for $1,000 in relief, we would like to propose an alternative. We would like to seek $851.34 in relief for the reasons stated below. 30 cents for the telegrams, a full refund of $175, $165 for, this is to account for $15 per day that services were delayed to account for the time that the defendant had to spend daily either distracted or clocked out from his job to correct the situation, which he is paid $15 an hour. So we're only accounting for 1 hour per day, which we feel is reasonable. He has had to leave work not only to seek but meet with new counsel at locations away from his job, requiring him to clock out from his home to correct the defendant's negligence. $400 for the defendant's deceptive statements, violation of my client's rights to terminate services, and breach of the Bar Association rules of professional conduct. $111.04 for the cost of retaining counsel for my client, which is applied based on the 10% of the sum previously mentioned items, which is our firm's fee.
Okay. And that's all the relief that you'd be asking for?
Yes, sir.
Okay. And did you have, so you've presented your exhibits, and I will go ahead and admit those into our arbitration here so that both counselors have a copy. Does the defense, have you taken a look at the exhibits that the plaintiff has submitted?
So my understanding is these new amounts have been changed from the original requests. So previously, the $1,000 totaling for the $175 for services rendered, $525 for expenses, and $300 for waiting time. That's what we were aware of. There was no modification for us to be aware of at that time.
Gotcha.
So no, we have no idea, sir.
Okay, and have you seen the exhibits? I think as far as the charges that the attorney may be putting forward, it is pretty well explained by the plaintiff's counsel what they're charging for here at this time. I would like to ask that the plaintiff's attorney please document those in a written format so that the defense's counselor may reference them. Just as a formality, if you would please. If you could just write down what it is that you're asking for in reliefs.
Absolutely.
And then, in addition to that, the exhibits. Counselor, I asked you about the exhibits. Did you see the plaintiff's exhibits that were presented in their complaint that they were referencing in their disposition?
Yes, Your Honor. In the original one, that is correct. I would have to reference. I would have to go back and re-verify. But the original ones, yes, that is correct. I have seen those.
Okay, perfect. All right. And is the defense counselor ready to go forward with their disposition?
Yes, Your Honor.
Okay. Then you may do so at this time.
Thank you very much. So we're here to discuss the case of Pierce v. Rugart. However, we have intended to present a countersuit for $1,000 as well for emotional damages, time and fees of the firm, which we would include receipts in our countersuit paperwork. However, we will not be doing that because we would like to cite McDaniels v. Reagan, where Miss McDaniels was awarded $50 for damages, where her initial demand was for $1,000 for lost revenue, physical pain, and emotional suffering. Chief Justice Longstreet himself can be cited as saying that the sum of $1,000 is absolutely absurd. Since 1% of the population has over $1,000 in their bank account at this current time, it would be unethical for that amount to be granted. Shamel and Whitaker firm are quite fond of quoting the Bar Association rules and professional conduct. In particular, they are citing the lawyer and law firm 16C, that, as we had just heard previously, a lawyer or law firm should not engage in fraud, deceit, or misrepresentation. Mr. Rugart is not a bar-certified lawyer, and his position as a senior partner does not make him the law firm either. He cannot solely speak for the firm, Ms. McDaniels, to collaborate. They have stated that Mr. Rugart has spread disinformation in Exhibit B. They are stating that because the paperwork was not officially submitted, that he lied to his client, when it is quite common knowledge that even the AG's office needs a minimum of 5 days to gather evidence for a discovery. Once we add on to the fact that Mr. Rugart was kidnapped from Blackwater by Anthony Rose and a Mr. Donnie from the Smoking Rose gun store and was held at the Italian's Manor in St. Denis, where he suffered severe mental trauma, this should be enough of a reason to encourage the prior Mr. Olson to show some compassion and be patient. Mr. Rugart took it upon himself to delegate the name change paperwork to Tom Smith, who, on the same day of withdrawing his application, this is referencing Mr. Pierce, submitted the paperwork just hours later. And I believe, if I may stop for a second, so I believe that it was 1 a.m. Pacific time, if we were correct in that, and then 12, so noon afterwards. So what is that? Is that 13 hours difference, 12 hours difference? If I'm not wrong, 11 hours.
Negative.
So I wanted to clarifying on that
That's
real
okay.
quickly.
If we could just take a moment here just to get some clarification.
If you look at the exhibits, you will find that the timestamps on the telegrams are in military time. It is not a AM/PM ordeal.
Perfect. Okay, so 1 a.m. then. Okay, so it was at 1 a.m. Pacific time, so that clarifies that. Thank you. So we urge the court to know that there was no formal contract signed, there was no receipt given, only an assumed promise and money in exchange for services. Mr. Rugart cannot be quoted as giving a time frame. It is a word versus word. Additionally, Mr. Rugart had reached out to Mr. Pierce and had offered an apology and Mr. Pierce's money. He refused and told Mr. Rugart to speak to his attorney. After receiving news about the lawsuit, the McDaniels and Rugart law firm stated a refund and a formal apology would be offered again. This was denied. Your Honor, this case is frivolous and absolutely absurd that even at this point we are sitting here today. And thank you.
Okay, perfect. So I've now heard both your dispositions, and at this time I'm going to be asking a few questions of each counselor just to kind of feel out kind of what we have and what we don't have here. So first, I would like to start with the defense. The most pressing question that I have is you just mentioned that there was offers of refunds to the client who is the plaintiff in this matter. Do you have any written receipt of that? That was sent by telegram?
I'm not aware if Mr. Rugart has that. I do know that during our discussion in the case file that there is written offerings. That is what we were willing to offer. So I can reference back to that in our newspaper. I can attempt to see if Mr. Rugart has that, but from my understanding from last night when we were discussing with my paralegals, that he had, for some reason, put 45 minutes to discarding of his telegrams to clean up his telegrams, if you will. And apparently because he has not quite had some clients in quite some time, which is part of the other countersuit that we were going to mention. But anyway, so I don't know. I would have to find out, Your Honor, and I apologize for not having
Okay,
that readily available.
Gotcha. That's perfectly fine, counselor. Let me come over here to the plaintiff. I just have another question as well. Do you have any record of this, of these offers that were extended? At this time, I would like to urge you that if you do have possession of these, that the court would like to see them.
No, sir. My client has not divulged any of these telegrams that claim to be offering a refund.
Okay. Now I'll come back to the defense counsel. We're going to move away from this and move on. So, something I noticed that I just want to make sure is clear is it, defense counselor, is it not true that the client reached out to your firm in order to terminate services?
Oh, are we referencing to an exhibit that was presented?
Yes, I would like to examine that exhibit. Counselor, if you could
Bear with me here.
Yeah. So
Actually, and I have yet to receive the new one. Mr. Whitaker, were you able to compile that for me, sir?
There hasn't been any new exhibit. I've been solely going off of the documents that were provided in the Pierce versus Rugart civil suit filing
Okay.
cabinet. It's
Yes.
just
The original from
the initial
Chanel?
complaint, correct? Yeah. The
Mhm.
initial
Okay, thank
complaint.
you. Okay, bear with me a moment then, please.
I believe that would be part of Exhibit B.
Thank
If you want to take a
you.
look there.
Let's see here. So, Wolfie is not the telegram, sir. It's MCR Law. That is our direct telegram to the law firm. Wolfie is Mr. Rugart's telegram.
Okay. And Mr. Rugart was the person that the client, the plaintiff in this matter, was working with?
From my understanding, yes. I'm not aware if there was anyone else that was working on it. I do know that, of course, after the kidnapping that he had, he, needed to, delegate, and he understood that this was taking a while for the prior Mr. Olson. So that's why I believe then that's why Mr. Smith had taken it on, because he had availability.
Okay.
And he's under different start times as well too. So I think that's definitely helped since I believe we all follow the Pacific Central and Eastern.
Okay.
So that's my clarification on why that was then sent over to Mr. Smith, and the time difference from the 1 a.m. to the I would imagine noon. Again, I would have to look at the military time there and do the conversion. But that was the difference in time frame, was that Mr. Smith, again, follows European stars. So
Gotcha.
I believe he would have been asleep at the time.
Okay. So I've been looking through the exhibits, and I've had them on my desk here while I was listening to each party's disposition, and there's something that I want to make sure is both clear, and both counselors can feel free to chime in here if you have any objections or any questions regarding this matter. But I noticed that in Exhibit A, if you look in Exhibit A1, you'll notice the date is March 3rd, and it was received from your paralegal, Mr. Wolfgang Rugart, signed his name. And he mentions that he had the paperwork done and prepared, and that he was able to file again. Would you be able to clarify that for me, counselor?
Let me see. I have your paperwork done up already. However, I had to run.
Yeah, it's
I'd
Exhibit
run to an
A3, I
accident.
think.
Yeah, I see. Yeah. The second telegram to Yeager from Wolfie. Able to file again. Sorry for the delay. I'm not sure what the word again would mean there. I do know Mr. Rugart is actually on his way. So perhaps I could ask him to clarify
Okay.
by taking a momentary recess once he arrives. But I would imagine the statement was meant to say, I am ready to file again. Sorry for the delay. So I
Okay.
believe the period may be improperly placed.
Okay, I understand. Is Mr. Rugart your primary witness? Are they the evidence that you're going to be presenting, or do you have any other exhibits that you would like present at this time, defense counselor?
Just Mr. Rugart himself. I'm not, unfortunately, there's nothing I can have besides just the statement of the sums are, even the modified sums at this point are incredulous. I'm not aware of any case that offers emotional boo-boo payments. Now, time away, I can understand, but if my understanding is correct as well, lawmen um, are on duty constantly, as was made apparent in Applewood v. the People, or sorry, People v. Applewood. And he would imaginably be able to check his telegrams at any point in time. So, I'm not certain where this, and I'm sorry. Do you mind reading off to me then, if you don't have it available, the relief that you're seeking, Mr. Whitaker, so I can write that down. And
yes, and Mr. Whitaker, when you go to do this, I just urge you, nothing against your rhetoric or the way that you speak, just make sure that you speak very nice and clear at a nice cadence, so that way everyone's able to write it down at a reasonable speed. I personally have it in my head here what your amounts were, but I do believe, just for the posterity of the other counselor, just because they're also going to be taking these notes, I would ask that you at least take your time while you're speaking. So go ahead, counselor, feel free to go ahead and relay your relief once again.
All right, give me just a moment. Let me get out my notebook, and I'm gonna write it down and put it in the same file as Pierce versus Rugart civil suit.
Oh, thank you. I would appreciate that.
Perfect. And while counselor, the plaintiff's counselor is doing so, defense counselor, if you could please cite for me what that case law that you were citing was, McDaniels versus or something versus.
Which one, sir? Reagan v. McDaniels?
Reagan v. McDaniels. Thank you.
Oh, that one. Oh, I would have to defer to Mr. Longshire. I'm sorry, sir.
No, that's perfectly fine. I just wanted to make sure that the citation was correct.
Yeah.
When we write the arbitration order, and
yeah,
my
it was
opinion
a
of the
civil
court.
suit that happened recently. I'm not certain if there was any
Yes.
documentation actually prepared.
No, that's perfectly fine. As long as you have the case citation, that's perfectly fine. I'll do all the legwork for that part. You don't have to worry about that any. You were just citing that, and I just want to make sure the record is clear. You're citing this to say that $1,000 relief is unreasonable. Is that correct?
That is correct.
Okay.
If I may.
You may, counselor.
I would like to cite that during that case, one of the main points of why the sum of $1,000 was too great, and Chief Justice Longstreet here can account for was one of the factors, and it was that no evidence was provided in the situation to account for any of the losses that were stated. I also want to add in there that these telegrams that we have, these are receipt copies of the to and from the client. They had a copy from the telegram office, and those timestamps are indeed in the client's timestamps. And even after Rugart received a cancellation that he did not want the paperwork filed, he still had the paperwork. He stated that the paperwork had already been filed, but it had not until an hour and 35 minutes afterwards.
Okay. And counselor, would you be able to present as an additional exhibit a copy of that filing when it was filed? As it seems to be the time that the filing was actually filed with the courts is pertinent to this case. Would you be able to do that for me?
Yes, I will go ahead and put that in the case file as well.
Thank you so much, counselor. I typically wouldn't have you do so much legwork, but just because it's pertinent and it's an issue that you've made pertinent in your argument, I would just like to have that on the court's record.
Okay.
So while that's taking place, defense counselor, you mentioned that you were going to have Mr. Rugart come and testify as to kind of his account on the whole situation and his involvement. Do you have a possible estimate as to the time that he will be arriving?
I would imagine if I were to close my eyes and guess about things, probably within the next 5 minutes or so, hopefully, sir.
Okay, perfect. Then we will go ahead. I'll let the plaintiff's attorney finish what he's doing here and get that entered
Thank
in,
you.
and then we will be calmly waiting. Once Counselor Whitaker has gotten all of that put together, we will call a short recess and wait for the witness to come, and then you both may examine the witness regarding this. I do want to hear what the witness has to say. Is they have primary involvement in this, and currently Mr. Whitaker's client is not here to testify on his behalf as well. So this will certainly enlighten me to kind of, other than the material evidence that's been presented, kind of the situational evidence that at least Mr. Rugart will be able to present to the court, so that I can make a fair and equitable ruling on this arbitration.
Absolutely. I wanted to clarify. So the relief in McDaniels v. Rugart was for the action of strangulation. The sum of $1,000 was to be paid for the pain and suffering. So the pain and the suffering due to the strangulation, which was shown with the evidence of the medical report. So I can put the complaint in your pocket, but there was nothing that was drawn up by Mr. Longstreet. Something I received, and I apologize. I may have missed it, but I received nothing in my telegrams or inbox.
Gotcha. Again, Mr. Longstreet is here in the gallery. If you'd like to give a little wave, he's here to certify that. So if this is incorrect information, certainly when we take our recess, you can speak with him directly, and he'll be able to give you the most accurate account, I'm sure, of what he ruled in that matter. I don't want to speak for another judge and what they ruled upon, but I will take at face value right now your both counselors' citation of the matter, and then if you wish to confer with him on some confusions you have, you may do so when we take our recess before the witness is called. Are there any questions in regards to that?
No, sir. No, there's no questions.
And Counselor Whitaker, you've presented that record to the file and cited.
Yes, sir.
Okay, perfect. Then at this time, we will go ahead and take a short recess, probably about 5 or 6 minutes until Mr. Rugart gets here. You may feel free to go about the courtroom, get some water, eat, do as you need to, and then Judge Longstreet is there in the back if you'd like to confer with him regarding his case law, if you need to refresh your memories on what actually happened, in order to further your arguments when we return. Are there any questions, or are we prepared to take our recess?
Yes, sir.
Yes, Your Honor.
All right, perfect. Then the court is now in recess.
All right.
Yes, sir. Uh-huh. Oh, perfect. Yeah, I've come to this. I've come to hang on. Excuse me. Let me just.
Woo! This has been thrilling. Wow. This has been an interesting arbitration, to say the least. How's it going, Mikhail? Oh, I was hoping Huckabee was still in here. Get what he thinks about it. How do y'all think it's going so far, chat? Order in the court. Order in the chat room.
Here, if it's all right with you, I can just ask for just a little bit longer of a recess. Since I believe it's been about 3 minutes has lapsed, if I'm not mistaken.
All right. right, counselor. I'll give you a few moments to discuss with your witness what you're going to be testifying about. You can just make sure that they're ready to go. We'll be returning here in 3 to 4 minutes. Is that
Okay.
all right with you, counselor? We'll be going back on the record.
Yes.
Okay. And defense counselor, did you need more time than that with your witness?
If we can, so and under my stars, it is would imaginably would be 7:34 now. Would it be all right to ask the court to, and as well, my apologies, sir, Mr. Whitaker, to additionally ask if maybe we could have until, let's say, 7:40, my stars,
It's fair.
so additional 6 minutes. Would that
Yeah,
be all right?
I think a 6 minutes would be all right. We can extend this recess for 6 minutes. I will approve that. You may take your time with your witness.
Thank you both. I appreciate it.
All right, no problem.
Associate Justice Pepper,
Yes?
just out of curiosity, is there going to be a desire for me to remain for any further clarifications on past rulings or decisions?
I do not believe so, Judge. I think you're good to go at this point. I've gotten the clarification on the cited cases, and at this time they're going to be questioning a witness. Hopefully, there won't be any more case citations at this time.
All right. Well, in that case, I will step out as I have some other business to attend to.
Perfect.
But if I am needed, well, send me a letter.
I certainly will, and I'll make sure that you know that we need you if something were to come up.
Yes, and when you're done, might be good for us to go for a ride and visit our constituents. As I don't think you've been around for a little while.
Yes, I think that's a good idea.
All right.
I will
I'll
send
be,
you a letter once
I'll
I've
be
completed here.
Well, just send a runner. I'll be over in on the other side of the building in my office.
All right, I will do then.
Okay.
Have a good evening, Your Honor.
Take care. Good luck.
Yeah, they kind of are, aren't they?
The important thing is I'm meeting new people.
I'm gonna take a guess and say that's Woody that just walked in. The unfortunate part about this situation is that my client's not here to give their side of the story. So if Rugart says something that goes against everything that I've worked for here, it's his word against the air. So, I mean, it's against what evidence is there. But my client will not be able to correct any of the statements or have any opposition whatsoever. So that does pose a difficulty in this situation, and kind of one of the very unfortunate things about roleplay, because he's stuck on the train still, 12 out of 24 or something like that. And we have 1 minute now. All right.
Okay. Thank you very much, Your Honor and Mr. Whitaker.
That's all right. So you ready to proceed, counselor? I'm gonna.
Yes.
Yes.
Alrighty. Defense counselor, since we're now back on the record, would you like to call your witness up?
Yes, please, Mr. Rugart. Will you stand behind the podium?
Yeah.
Perfect. And though this is an arbitration, this is an informal hearing. However, we are going to swear you in because you are giving sworn testimony to the court. So, Mr. Rugart, I know that you've worked as a paralegal attorney, so you know the drill.
Yeah, yeah.
Do you promise to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, perfect. Then we can proceed. All right, counsel, you may begin your direct examination of your witness. Remember, the rules of trial and questioning are here, so the rules of evidence do apply. So please be aware, both counselors. Please proceed.
Thank you, Your Honor. Mr. Rugart, how did you meet the former Mr. Olson?
He had reached out to me via Telegram. I believe he had seen one of my posters around Valentine.
I see. And would that be... And what kind of poster would that be, sir?
I basically had a business card, I would say inflated to the size of a poster, that I would tack up on the pin boards over there at the train stations.
I see. Do you have a copy of this?
Not on me, but I can get you one.
Okay. Would it be the one? And Your Honor, we're happy to put that into the case file here, so you can have that what he's
Okay.
referencing if you would like it.
If you feel
It
it's
was the
pertinent, you may
prior
enter it
one,
as
too.
evidence. That's perfectly fine if you feel it's
Okay.
pertinent.
Yes, we'll go ahead and I'll enter that while Mr. Whitaker is crossing. Okay, so then you two had an engagement between telegrams. When did you physically meet the former Mr. Olson in person?
I would say late February.
Okay.
Probably around the 23rd or so.
Okay, so
I'm not sure exactly.
That's okay. So you two had a discussion. Tell me what happened during that discussion. What was discussed between the two of you?
Well, the gist of it, without revealing confidentiality, was he was getting a divorce and he wanted a name change. The divorce didn't require court proceedings or anything. They basically came to an agreement where they would split their money from their possessions. So I took up the paperwork.
Okay, so their divorce was amiable. Why did Mr. Yeager explain why he wanted a name change?
No, he never really explained that to me.
Okay.
I never really asked him, I just, it's people's own prerogative what they do, so I try not to fiddle too much into it.
Absolutely. Now, so part of the name change process is you are required to go down to a lawman or the sheriff's office or a marshal perhaps, someone who has access to public records, and make sure that there's no criminal history. Had you done that?
Well, under my assumption, he was a sheriff. He had access to records and everything, and I had asked him if he had a criminal record, and he told me no.
Okay, so you took it on his own oath, being a lawman, that he was, without criminal record. Okay, thank you. Moving on, I wanted to bring up there was a bit of a time delay. So the 24th. Sorry, I'm just referencing.
That's okay. Take your time.
Okay. So I'm referencing the original civil suit here that Mr. Chamel had brought in, that being Exhibit A. I believe it is the second and third telegram dated to 24th of February 1899 and the 3rd of March 1899. Why was there such a time delay, sir?
Between that period, so whenever I had taken up Mr. I believe his last name's Pierce now. I'll call him Olson the prior. Mr. Olson's case, between that time I had gotten kidnapped and taken hostage by Mr. Alex Rose, and
Was
I'm
that
not
Anthony
sure.
Rose or Alex Rose?
Alex Rose. Anthony was there as well.
I see.
Yes, ma'am. But I had gotten taken hostage, taken over here to the Italian mansion, and nearly lost my
Sorry,
life.
sir, if I can clarify, where is here to the Italian mansion?
Saint Denis.
Thank you.
There's a mansion owned by, I believe, either Sal or Luca, or
Luciana
Luciana
DeLuca.
De Luca.
Would that
Yeah,
be
yeah,
Luciana De Luca? Okay.
yeah.
Alrighty.
They own a mansion in back streets over there on, I call it High Roller Row, you know.
I see.
Objection narrative.
Yeah, this has been going on quite a bit. I will sustain that objection. Counselor, please break those down into,
Yeah.
Well,
bite-sized questions if you could.
Yeah. Well, so I mean, here's the thing, though, Your Honor, is that this is relevant because we need to know why there was such a large time gap. The former Mr. Olson is complaining that there was, there's no response, that he's having a hard time basically, getting this filed, and he's suffering emotional distress from this. Mr. Rugart had the inability to reply to telegrams, to post the paperwork necessary when he's going through these things. So this is quite relevant to know.
Counselor, I will agree with you in that it is relevant. However, the objection was to narrative. It's just to the form
Okay.
of the question. If you could ask questions that elicit this information
Sure.
in a shorter fashion, so it's just not Mr. Ruger telling the whole story,
Okay,
and instead
that's fine.
do it through questioning, that would be preferred.
Less testimony. I understand.
If I can break it down, basically I was taken hostage and nearly lost my life because I was, nearly shot in the head.
Okay.
Continue your questioning, Counselor. Continue your questioning.
Thank you, sir. Thank you, Your Honor. So then following that, there is an Exhibit B. It's marked as the 7th of March, 1899, that you then sent a telegram. Is that correct?
I believe so.
Okay. So that was the next time you had communication. So that's 4 days later. Following that, I apologize. No, excuse me. The first one, excuse me. Sorry. When it's looking to the from, it takes me a minute to adjust my eyes. I'm a bit old here, gentlemen. So the first one was dated 1:50 in the morning. This was Mr. Yeager canceling as an assumed contract. What contract did you have with the former Mr. Olson?
I had no contract with him.
I
There was
see.
no written contract or anything like that.
Did you provide Mr. Olson with a receipt for these assumed fees that you collected?
No.
I see. So there's no
He
contract.
never asked for one, nothing like that. So no.
Is it normal practice for McDaniels and Rugart Law to not supply receipts or contracts for wills or paperwork of
If
such?
it's asked, then we always.
Thank you.
Yeah, if it's not asked, probably no.
I see. Following that, I wanted to move on to, and we can see the exhibits where we can clearly see that we understand them. Moving on to, why is it that you elicited the services of Mr. Tom Smith to submit the paperwork?
Objection leading.
How is that leading?
Counselor, if you could restate the question just so we can have it on the record, and then you may respond.
All right. I'm not aware of how it's leading. So, Mr. Rugart, why did you ask Tom Smith to submit the paperwork for you?
Gotcha. I would argue that this does kind of elicit a response. So a leading question is a question that elicits a very specific, targeted response from the witness instead of leaving it open to the witness. I would ask. I will be overruling this one because I do want to see where this goes, but I do understand the objection from the plaintiff, and that will be noted. So go ahead and continue your questioning, counselor.
May I elaborate on it? So the reason why, additionally, why I'm mentioning this and it's needing to be known is co-counsel had made it noted that why is it that Tom Smith was the one who submitted the paperwork when they're saying it should have been Wolfgang himself? So that is the reasoning for bringing it up, so we can make it, hear it from him why it is that he chose to delegate this,
Yes.
because I believe the complaint is that there was no delegation previously done.
I
So-
will overrule the objection on
Thank
this
you.
matter. I agree that it is possibly a leading question. However, because I think that the answer is pertinent to the court, I would like to hear the witness's response. So I will go
Thank you,
ahead
Your
and
Honor.
give you this one question to let you finish this line of questioning. If it doesn't go anywhere, just know that we will be moving on. Okay, continue your question.
Absolutely. Thank you, Your Honor. So please, if you could answer the question.
Yeah, so I was moving some more stuff from the north and then the rest of my stuff from over here in St. Denis, so I was very, very busy and not available to basically file any paperwork. So I had given that over to Tom Smith so that he could get it done really quick. I had also
Thank
given
you.
him 2 other cases.
That's fine. Thank you.
Hmm.
Alrighty. Before you had arrived, sir, we were discussing that there was a statement that was made in the telegram. Where was it? It was the one for the 3rd of March, 1899. The statement was, "Hello, my friend. I have your paperwork done up already. However, I had run into an accident and now I am able to file again, period. Sorry for the delay, period." So we wanted clarification, Mr. Rugart. There was an assumption that uh, this period before sorry, um, I, I'm under the impression that it was meant to be again sorry. So file period again sorry. Can you
Objection
clarify that?
leading.
Counselor's response. So I'll let the defense
It's
respond.
yeah, it's not leading, Your Honor. It's asking for clarification.
While I do see your point that you're trying to clarify here, counselor, I will have to agree with the plaintiff's attorney in that the question is,
Your
it was
Honor.
essentially you giving a statement. I would like you to rephrase the question if you can.
Okay. I mean, I'll be honest, Your Honor. If we keep going down this path, there's really no point in continuing with the questioning. I'm asking him to essentially read the telegram and
Counselor, I
state
can,
for clarification what he meant.
counselor, if I may, I'll try and assist you in this matter. I would like to ask the witness a direct question, if that's all right.
Thank you.
Yes, sir.
And I just want to clarify that you are trying to have the witness recognize Exhibit B. Is that correct?
Yes, the telegram marked the 3rd of March, 1899, 10:29:16 Eastern, which we know is Pacific now, but
Perfect.
that is correct.
Okay. Witness, have you seen a copy of Exhibit B? Do you have access to that as your counsel?
I have seen a copy.
Okay, and are you looking at it with me here? Did you write that telegram?
I did, yes, sir.
Okay.
It was very early in the morning for me.
Okay. And you certify 100% that this was sent by you, is that correct? I will ask this leading question just to get this to the point.
Yeah, that was 100% without a doubt me. My telegram
Okay.
to Wolfie.
All right, perfect. Then we'll certify that this has been written by the witness. Counselor, you may continue your questioning.
Thank you, Your Honor. Bear with me, please, while I gather my thoughts.
That's perfectly fine, Counselor. Take your time. There is no rush.
I'll be honest, I'm not sure how to phrase the question that I'm wanting to ask. That's why I'm trying to think of an educated way to say it.
I understand. I
Uh,
understand.
um, did the former Mr. Olson ever request a refund from you, sir?
A refund.
I'm sorry. Let me for services rendered.
He stated that he wanted to terminate a contract. I basically had written him back and apologized, and then sent him a telegram after and had offered money back.
I see. Do you have that telegram?
No, but I'm sure I could get a copy of it if needed.
I see. Your Honor, with that being said, I mean, is this something that she would need to see now, or would you accept the word, and also would co-counsel accept the word that was sent?
Well, you'll have to ask the opposing counsel if they would accept that. The court doesn't have a document in front of it, so it's very hard for me to certify whether it exists or not just on the word of the witness. I will leave that up to cross-examination, and the counselor can question it, and then we reconvene on this matter once we finish the questioning of the witness. Counselor, so at this time, just continue your questioning, or if
Wonderful.
you're... Yep, go ahead.
So you um, I'm sorry, Your Honor. May I take a moment to sit down?
Certainly, certainly. Please feel
Thank
free
you.
to take a
I'm
moment.
feeling a little shaky here.
That's okay. Take your time. Drink some water. Um, let the counselor recover themselves very quickly, and then we will continue the questioning from there.
Okay. I think I feel a little more recovered. Alrighty, Mr. Rugart, did want to ask you, at any other point in time, did you offer a refund besides this alleged telegram that you had sent?
Yeah. We offered out through the firm a refund as well, and a formal apology again, and yet it was denied.
Sir, where do you have proof of that? Where was that made mention?
I believe that we had even written Favish that we'd give a refund.
And for the record, could you certify who Fabish is in this case? The full name of the individual.
Favish Shamel. I'm not exactly sure how to pronounce his last name. I apologize.
I believe he was the former the original counselor who had submitted the paperwork for Mr. Olson.
Okay, perfect. Original counselor who submitted the paperwork. All right.
Yes.
Continue on.
I'm sure the co-counsel and his honor here would be curious. Can you, if it's okay with you both, can you clarify where this is again, please, that you had offered this refund?
I believe it was in the newspaper.
Which newspaper?
The law newspaper. if I'm not mistaken.
So okay, sir. I guess I'm not understanding. Which law newspaper are we talking about here?
Okay, so there's a law newspaper. If you get an issue daily, then you'll see an article about a civil suit, Pierce versus Rugart. It's
I
that
see.
article.
Okay, I see.
If you look through all the lines and all the talking through there, then you'll see it.
Wonderful.
I don't know if we offered it more than once. I know that we offered it at least once.
Wonderful. Thank you, Mr. Rugart. I have no further questions at this time, Your Honor.
Okay, perfect. Thank you, counselor.
Thank you.
Plaintiff, would you like to cross-examine the witness?
Yes, sir.
All right, Counselor Whitaker, you may begin your cross-examination.
All right. So, Mr. Rugart, when you sat down with previously known Mr. Olson, what did you discuss as far as payment?
What was that?
What did you discuss payment wise when you met with Mr. Olson at first?
I didn't discuss any payment at first. I had heard his case, heard what all he needed done, and I just charged him basically a counseling fee with a service charge.
Did you discuss a time frame?
I said that I would be able to get it done in a few days, if I remember correctly. But then, like I had stated, when Miss McDaniels had questioned me, I had ran into an accident where I had gotten kidnapped from Blackwater, which I believe there's a medical record for and everything for that as well. Yeah, no. I had told him that it could possibly take a few days. I didn't give him an exact time frame or anything like that.
What payments did you receive from Mr. Olson?
Just one payment.
And what was the total of that payment?
175.
Okay. Do you recall the date you were kidnapped?
No, I don't recall the exact date. My
That's fine.
mind was extremely fuzzy for the next couple days, so I didn't recall a lot. I knew what happened to me in the house, not much after that.
Okay. So I want to turn attention to Exhibit B. Article 1 and Article 2. So during this time frame, what had occurred during this time frame?
You said Exhibit B?
Exhibit B, Article 1 and 2. It would be from 1:50 in the morning at Pacific time until 11:05 Pacific time.
Oh, well, that's easy.
Objection relevance.
It's relevant as to determine what happened between the time my client sent the telegram to when Mr. Rugart received it.
I believe that's a simple misunderstanding of the stars. I was asleep.
Okay, so
But since there's an objection on the floor, before we continue, I would just like to mention, as far as to relevance, I would like to overrule that objection at this time, just because I think that the material regarding the evidence that's in record is rather important. So I would like to hear kind of information regarding that if we have some clarifications. So I'm just going to overrule that objection at this time, and the counselor, you may proceed with your questioning, just to address the objection on the floor.
so you were asleep at that time.
Yeah, I was asleep. As soon as I woke up, I had basically sent telegram. I had given the paperwork, I believe, the night prior. I mean, I guess a few hours before he had sent that telegram. I'd given that paperwork to Tom Smith because I was just now getting around back into town.
Did you confirm that paperwork was submitted?
Did I confirm that it was submitted?
Mm-hmm.
By Tom Smith?
Yes, sir.
No, I figured that Tom would have submitted it. I was going to check back up on it within a day or so. As my understanding, there's, no set time frame to turn paperwork in, really.
After you received that telegram from my client and then sent this one, Article 2 in Exhibit B, did you reach out to Tom Smith?
Tom wasn't awake yet. As soon as Tom woke up, I was around. He was at the Porter Tavern where he'd fallen asleep.
Okay. Did you reach out to Tom Smith about the telegram that you received?
Your Honor, objection. At the moment, it's very slight, but it's slightly badgering the witness when he continues to reference Mr. Smith.
Oh,
Your Honor?
Counselor. Yes? Can you hear me?
Sorry, you had a frog in your throat, I believe, unless it was my ears.
Oh, no, it may have just as well been me. Counselor Whitaker, if you'd like to respond, I will give you a chance to respond to this objection. The objection is badgering. That you're badgering.
I don't understand how I'm badgering the witness. I'm only asking him what he did after he received the telegram from my client.
Okay.
So, would you like me to respond, Your Honor?
You may, and this will be the last response before I rule.
Thank you. The reason is because, we've discussed already that Mr. Smith had received the paperwork. Why would further follow-up be required?
Gotcha. I will be. So it's okay. I'm going to be overruling this objection. However, I would like to be noted that I would like this line of questioning to be wrapped up fairly quickly. I do see the defense counselor's point in their objection to the very least, and so I do believe that you should wrap this up, counselor. Please make it quick, but I will let you continue this questioning just a little bit further. So go ahead, counselor. Continue your questioning.
Absolutely. After you received the telegram from my client, did you reach out to Tom Smith about that telegram?
Right out to him. No, Tom is. I usually know Tom's schedule. I knew whenever he'd be around. So I waited around at the Porter Tavern where he had fallen asleep at the couch on the couch. Waited until he woke up and talked to him then.
Okay. Nothing further, Your Honor.
Okay. Counselor, will there be any redirect of your witness?
No, Your Honor. Thank you.
Okay, Mr. Rugart, you're free to step down. Thank you for your testimony.
Thank you.
Presented, and with the witness's statement now being held in credit to the court, each counselor, you may take a moment to make some closing remarks. I will start with the plaintiff's attorney. You can go ahead and make some closing remarks on your case, what's been presented, and what has been said by the witness, and then I will give the floor to the defense's counselor. Plaintiff's counsel, you have the floor.
Okay, so during this arbitration, we've established that Mr. Rugart did in fact receive payment from my client. We established that he did have an unfortunate circumstance happen during the time frame, and after his return, he did show that he was moving forward. This still took additional time, and my client had reached out prior to the documents being submitted. We've also shown that during the situation, there was a notice of confirmation that the documents had been submitted without indeed confirming that they had been submitted, and no attempt to telegram the Mr. Tom Smith in order to prevent the paperwork from moving forward. We've also established the. To be honest with you, I only had my opening statement here.
No, that's perfectly fine. Take your time.
Take your time.
Yeah.
All right.
Oh, Your Honor, we're willing to give Mr. Whitaker, we can call it 3 minutes if he wants to gather his thoughts, if that's enough time you feel, Mr. Whitaker, if
Sure.
Your Honor will allow it.
I will perfectly be comfortable with allowing that, Mr. Waiter. If you need the time, you may take just 2 or 3 minutes to recollect yourself before you proceed with your summary statement. If you need that time, that'd be fine. If you're ready to proceed, the court is ready to hear you.
All right. I believe I will take a few minutes.
Perfect. Then we will reconvene here in about 3 minutes. We'll start according to Eastern Standard Time. That'll be 3 minutes at 11:13 for everyone else. Just as on the 13th minute. So just take 3 minutes, and then we'll proceed.
All right.
Just
Okay.
co-counsel. Are you good? Okay.
Yes. All right.
All
Sweet.
right, you were ready to proceed. Good.
So we have shown here today that the defendant was negligent in their duty after the incident had occurred in which they were kidnapped. The time frame after the situation, there are claims of mental and emotional distress, but there is no documentation nor evidence to support this statement. Furthermore, we have shown that Mr. Rugart did indeed receive payment, as well as a telegram to cancel his services, which was not communicated forth to Tom Smith, nor was it confirmed if the documents had actually been filed. Instead, Mr. Rugart took it upon himself, without factual knowledge of it, to state it was completed. At this point, the plaintiff had terminated the services as they did not desire for the documents to be move forward. just prior to this, the defendant had reached out to counsel in order to correct a situation that should have already been processed. Lost my train of thought there. Sorry.
That's okay. Take your time, counselor. You're doing good.
And just prior to them requesting the cancellation of services, they had to reach out to separate counsel in order to express their wishes and figure out what they should do moving forward. That'll be all.
Okay, defense's counselor, the floor is yours for your closing statement here. Go ahead and give your closing remarks, and then we will move on to the deliberation and ruling on this arbitration. So go ahead, counselor. The floor is yours.
Thank you, Your Honor. Well, payment is not being denied. The money was offered to be refunded on separate occasions. The former Mr. Olson refused that payment. Additionally, the former Mr. Olson was rather obdurate in his position. There was also never a contract to be voided. Mr. Rugart's unfortunate circumstance of being kidnapped and nearly shot in the head should be reason enough to encourage this court to agree that anything over $175 would be egregious. The fact that Mr. Rugart reached out to a paralegal in the firm should show face that Mr. Rugart was understanding of Mr. Olson's position. Your Honor?
I'm still listening. You're good. Go ahead.
We recognize the fact that Mr. Olson, Mr. Pierce, the former Mr. Olson, did have to wait some time. We were confused why he wouldn't have reached out to the firm itself. But that being said, attempting to rectify the situation, the firm acknowledged it and attempted to refund the money, to which his counsel had declined that. So, it's being said enough that $175 and an apology being offered should be more than sufficient. That is all, Your Honor.
Alrighty. Thank you, counselor. I'm just going to take a few minutes to collect through all my thoughts on this matter, and then we'll move to the ruling on the arbitration. So just give me five or so minutes, maybe less. I'll call us back to order. You may, at that time, eat, drink, make yourselves comfortable, and then we will move on to my ruling on the matter.
Thank you, Your Honor.
Thank you, Your Honor.
No problem. Thank you, counselors.
I'm going to talk to How you feeling, Felix?
To be honest, this has actually been fun. This has been interesting.
Yeah. You're doing good. You're doing really good. I apologize for my my brief lapse. I feel I may have been a little lightheaded from not drinking any water. Foolish of myself. So I appreciate you allowing me the momentary recess there.
That's all right. It's sometimes your mind just gets away from you.
Yes, absolutely. Yeah, no, you're doing wonderful. I commend you. So we'll see what happens.
Absolutely. It's definitely this has definitely been challenging and definitely been it definitely has gone better than the last time we sat in an arbitration. So
Yes.
I definitely have been enjoying this, and it's interesting to say the least. I like the arguments that you present. You do very well. I like the counters with what was it?
Badgering.
Well, I was saying with the what you call it, mentioning precedents that were set.
Mhm.
So all of it, you're doing really well.
Thank you. Definitely not on my game tonight. The pit bull is not pit bulling, I suppose.
Well, after everything that's been happening the past week, I'm not surprised if anybody's not on the game tonight.
Yeah, it's been crazy. We've been crazy busy at the candy store, and then my boyfriend has the whiskey distillery as well too, and we've been trying to catch up on orders, trying to reach saloons and taverns and trying to fulfill all of those orders. I had an order last night that was like over almost $300 for candy alone.
Ooh.
And I was luckily able enough to have supplies. Prior to that, I had one that was $500, and I had to make 150 peppermint patties. So
Oh.
you can imagine how long that would have taken.
Yeah. I've
You
got to make
know,
100 horseshoes whenever I get back to the
oh, there you
fort.
go. See, yours is more physical than mine is. Perhaps I'm simply just looking over, uh, chocolate. Although I will say, tempering chocolate, if you haven't done it, is quite difficult.
It would just make me hungry.
Yes. Yeah. You know what's interesting enough?
Hmm.
I like candy, but I don't love candy. I like seeing other people enjoy the candy.
Oh, I love candy. Candy is my favorite.
Well, great. You
I
should come down sometime then.
All right, y'all are over in Blackwater, right?
No. So, um, my store is in Armadillo now. Um, and we have the ice cream store, which is now under the luxury brand. That is in or going to be in Blackwater. Um, and then we have the Dusty Cactus, which is a general store in Tumbleweed, and then of course my boyfriend's distillery, Blarney Stone, which surprisingly, do you like whiskey, sir?
I do.
Perfect. I'll have to bring you a bottle sometime. I keep forgetting to bring Longstreet one. I'm always thinking about it, but I always forget to grab it on the way out. His family has owned it since the 1500s. I
Mm-hmm.
don't exactly remember what year it was established, but in Ireland, so a recipe over 300 years old, you know, has
Mm-hmm.
to be worth something. But that's how long, yeah, his family's had the distillery. And he actually created honey whiskey, which is pretty interesting. I don't know if you're a fan of honey.
Oh, I love honey whiskey.
Oh, good. Oh, so you've had some before then?
Yes, I have.
Wonderful. Most people have no idea, you know.
Oh, it's delicious. Just the sweetness, or the sweetness, the
Okay,
sweetness
ladies
to
and
go
gentlemen,
along
I'm
with.
ready to
Oh,
give my ruling. So just get yourselves comfortable, and then we'll go back on the record whenever you're ready.
All right.
All right, counselors. I have reviewed the testimony of your witness, the exhibits that have been presented to the court, and have given a thorough examination to all. And at this time, the court has reviewed that a few things are true and should be noted as fact. One, that the plaintiff did issue payment to the defendant's firm, and that at least an amount of $175 was paid to the firm. This is true, and this is noted as fact on the record, not just by the testimony given by the defense's witness, but also by certification. That's what the whole suit's about. In addition to this, the witness mentioned that they charged a service fee, and that was never clarified on. So I'm assuming that payment, based on that, I am making it. It makes it clear that payment has taken place and that funds were exchanged. Now, as to the circumstances, they are unfortunate. The witness's circumstances, while tragic, do not excuse them for their professional conduct. When an attorney accepts payment for a service, this is essentially consideration for a verbal contract. A contract is not always a written agreement between a purveyor and a receiver. There's consideration given by both sides, and once payment is exchanged, the exchange of goods takes place either by a means of exchange of goods, services, or money, then a verbal contract is initiated. In this case, I think it's very clear that a verbal contract was initiated between the plaintiff and the defendant. The defendant being the law firm in question. The telegrams and their communications make it clear that there was an agreement for services to be exchanged. When services were not exchanged in a timely manner, there was a request to terminate service. A client, just like a lawyer, has a right to terminate service if they believe that there is just cause. Now, determining if there is just cause, we must review the evidence. There was a period of time where Mr. Rutgard was indeed incapacitated due to a tragic event. We are unsure about the exact date of that event, but we assumed that the tragedy would likely cause Mr. Rugart at least 2-3 days of being incapacitated. Mr. Rugart was initiated service on February 24th, but it wasn't until March 7th that termination was requested. There is a period of time of 2 weeks that reasonably Mr. Rugart should have been working on the paperwork and could have presented at least a rough draft to the client to assure that service was being taken seriously. I do not have evidence presented to the court whether Mr. Rugart did or did not perform his duties properly, and will not be considering that in my ruling. However, I must note that because service was rendered after termination, that this is a cause for malpractice. That being, your license of the attorney is not in question. Rather, malpractice is simply in this a misunderstanding or a practice that took place not of maliciousness but of negligence. I will be ruling in favor of the plaintiff because of this, and I will be ruling that they will be returned the $175 as payment, as compensatory. In addition to this, I will be issuing $100 malpractice to the plaintiff as punitive damages for services charged in a misrepresentation. This will not go as a record to the attorney's law firm and will not go on record as the law firm committing anything other than a misunderstanding and a failure of practice. This is not a malicious practice case, but rather just a failure in practice. In addition to this, because there were legal fees that took place, we will give consideration to legal fees to the total amount based on what the plaintiff has calculated. The plaintiff receives 10% of contingency, and so consequently, we will calculate that at this time. We have currently $175 compensatory and $100 for the malpractice punitive damages, which comes out to a total of $275 as a reward. This $275, when calculating that 10%, returns a yield of $27.50 for attorney fees. The court will be considering that as part of the judgment for this arbitration. Bringing the total that we have now before us, the $275 with the $27.50. Because the 50 cents is awkward, and for posterity, I'll be rounding down just actually, we'll round it up to the $28 for the attorney, and we would bring us to a total of $303. A judgment for $303 to the plaintiff at this time is what the court will be issuing, simply for the fact that services were rendered and a service after termination was executed. Other than that, I do not see any other wrongdoing on behalf of the attorney. The attorney was simply acting as they saw fit, be it against the interest of the client. The only violation that took place here is that it happened against the will of the client, and that is improper. I would like again to note as a dictation for this arbitration for future purposes that an attorney and client both have the right at any time to terminate services between each other through writing. A written termination is the only way in which termination may be recognized by the court. A termination by word alone will not be recognized. Because there is written termination, this is what the court is using when making its ruling.
Thank you, Your
And that is
Honor.
the ruling of the court.
Thank you, Your Honor.
We do want to make mention that we would like to file for financial relief. Mr. Rugart is not a wealthy man.
Sorry.
So
I understand. Keep going. Sorry. Continue.
Yeah, that's okay. Thank you. So just basically to sum it up quickly, he does not have $303. His business is not open yet, so he has no essential way of, gaining that money. He is allowed, from my understanding, to sell his drink and food outside of his establishment. So he's allowed to do like a traveling vendor, if you will. I have something similar where I do a traveling merchant. Our parent brand luxury for the food items and whatnot. We do traveling, sales because we have the permits to do so. So essentially what we're seeking is financial relief of $100 off. He does have $200 in his bank, but he does not and probably will not have the additional 103, if I'm understanding correctly, is now instead of 102.50, it's now 103. Is that correct, sir?
Yes, that's correct.
Thank you. So, we're asking for the financial relief of that additional 103 to just make it the 200. Is that
perfect? I will consider this, and I would like to make it as part of the dictation of the court for this ruling. Something I wanted to mention that I'm glad you reminded me is that I would like to note that the defense's counselor brought up Rager versus McDaniels, which is an arbitration agreement that happened between an individual for an assault. It is asking for asking for damages to recover from an assault. As in this case, um, it was ruled that there was no proof of damages to which a reasonable ruling could be made to determine anything higher than the $50 return which was yielded by the court. In this matter, we do have set damages of at least $175, which makes it clear that there's at least a set amount to justify the $175. I have received and will consider the defense's request for relief, as it is fair to say that the individual who is being sued may or may not be able to make payments on that judgment. In an attempt to offer fair relief to the defense, to the defendant, we will be giving a discount of $100 to the judgment. However, the legal fees will remain. The $175 will be returned to the plaintiff, and in addition to this, we will be discounting that $100, and instead we'll be rounding up a little bit more, so it won't be exactly a $100 discount, but we will be moving to $215 to consider the legal fees and pain and suffering, and making that a quite severe discount. Would that be agreeable to you, old counselor?
Yes, yes, Your Honor. So I just clarified that yes, he can make that payment, and I believe we can probably do that once we convene here, if that's all right.
Perfect. Then we will consider that motion to be granted, and we will offer relief to the defense in regards to the judgment in the amount of what was $303. We will give a relief of $88, bringing us down to $215, which will be the official judgment of the court and shall be issued and payable to the plaintiff. If there is complaint that there is not payment within 7 days, within a week's time, there may be further action taken against your client, and there may be criminal responsibilities that they may have to meet. This debt obligation needs to be resolved as quickly as possible, as all parties understand this. We will go ahead and adjourn this arbitration agreement. So speaks the court.
Thank you very much, Your Honor.
I want to
Mr.
make a note, now that we're off the record, I just want to make the note that both counselors did a wonderful job. I believe that as far as this arbitration goes, both counselors phenomenally done. Phenomenally done. So you have my congratulations to both of you for a job well done. Court is now dismissed and we are adjourned.
Thank you, Your Honor.
Thank you, Your Honor. We appreciate you still making it out. I apologize for my schedule being as it is. It's not something that it used to be. I'll be very honest with you all. It's much more hectic than it was once.
No, I appreciate your all's patience. I myself have been extremely busy as well, so I completely understand.
Yeah. Ms. Whitaker, if you want to join us at the bank, I believe Mr. Rugart can make that relief to you as soon as we go over there that way. And I'm glad, Mr. Pepper brought up, Honorable Judge Pepper brought up the great point of it's so when you're looking at your clients when they're are paying or not paying, it's the same thing as if you have someone who's a criminal client or alleged criminal client. It's when they have to pay those fees that they're being charged with. It's the same kind of thing. So I don't know if you're aware that when they have let's say there's public nuisance example, it's like $25, I think. They need to pay that immediately. Don't make them wait. Make them pay it right there and then. Tell them, no. I'm paying you my money. Like, we're not going to have a warrant out for my arrest. So, just whenever you have clients in the future that, do anything like that, just please make sure they pay. Because I've had a client where he had a warrant put out for his arrest and an additional 300, I think, Wolf, was it not? And 100 and something hours, or sorry, days, 180 days was charged against him in addition to 300. So, something to consider.
Okay.
Alrighty, well, let's get over to the bank.
All right, let me grab my coat.
Oh, time to grab my hat.
Yeah.
Um, Judge
Yes, sir.
Pepper. So, is there anything that guarantees a right to privacy in the state of Monroe?
So in I believe the attorney's professional codes site, it may not be there. It was at one point in time where there is a right to privacy in attorney-client privilege. If you're talking about public privacy, I would say that's covered under your search and seizure amendment. That's where your privacy would be held.
Do you think that when it comes to a defendant, or not a defendant, but uh, for instance, the plaintiff, it was mentioned that there may be a countersuit for a, what do you call it, for uh, violation of privacy with a, um, what do you call it, for the telegrams, but the telegrams are my clients, are they not?
I mean, if the client, any communication between a client and their attorney is the client's, the client has custody over that. They have a
Okay.
right, and they have a right to that. And I mean, as long as they were presenting it to the court as a matter of fact, then it's not a violation of privacy as far as I'm concerned. The client has a right to that information, just like their entire case file, any document filed, the client would have a right to that document.
Okay. Just wanted to make sure. Thank
Yeah,
you.
I mean, if it was like an internal note made from one attorney to another, or an attorney's note to a paralegal, that's business records. That's different. But if it's a communication between client and attorney, that's their record.
Okay.
So I see no reason that violates any sort of privacy. Attorney-client privilege doesn't work both ways. A client has the right to give privileged information about themselves and their cases as they'd like, but an attorney
Mhm.
has duty to hold on to that privilege. Whereas
Okay.
a client doesn't necessarily have that same duty. It's not like the client is taking secretive information from the attorney that needs to be protected. The attorney is assisting the client in the matter. So
Right.
that was just my opinion on it. You may talk to Arthur and see someone's totally different perspective, but that's just what I would think.
True. Yeah. Thank you for your time today, and I appreciate the kind words at the end. This is the first litigation I have attended just by myself.
Yeah, no, it was excellently done. I think that your statement was wonderfully done.
Thank you. Right, it was a pleasure to actually finally get to meet you.
Oh, the pleasure is likewise. But like I said, both counselors did a great job. There were some objections thrown out. There was a lot of questioning. I believe that the statements, everything had some legal backing. I believe that everybody had some logic behind what they were trying to put forward. At the end of the day, just like all things, we have to come to one conclusion. But I could understand the angles from both counselors, which is a blessing, to be honest. I've had cases where both counselors are lost in the woods and have no idea what direction they're wanting to take. So at least both counselors had a clear direction they were going, which is a blessing to me. I think that makes it a lot easier on everybody to not make such logical leaps and bounds to come to that conclusion. So good job to both attorneys on that behalf.
Thank you. All right.
Thank you very much. Pepper, too, when you have a minute, we wanted to ask you something. They're going to take care of the relief. But Mr. Rugart and I wanted to ask you something.
Oh,
Mr.
certainly.
Rugart, do you have something I can write in so that I can confirm that you received payment?
No. You're
Did you
it's just
did you
word of
receive the
mouth.
payment? Because I'll act as a witness to it as well, since I'm here.
Okay. Yes, he did indeed pay me $215.
Okay. Payment has been certified. Judgment has been executed.
Oh. Well, y'all be safe, and I suppose I'll see y'all around. Oh, real quick, Miss McDaniels,
Yes, sir.
am I mistaken in thinking you own Spoonful of Sugar?
That is the one we were discussing, yes, in Armadillo.
Could I get your telegram?
Sure. So there's technically 3 of them. Allie is my personal, ALLI, Alpha Lima Lima India.
Mm-hmm.
Luxury gets you anyone in our company. It's a parent company to the companies that we all own, LUXURY. And then the firm's telegram is MCR Law.
Okay.
Right, Rugart, MCR Law?
Yeah.
Okay.
McRugart law.
All right. Thank y'all, and again, wonderful job, Miss McDaniels.
Thank you, sir. You as well. It's good to see you.
It's good to see
And I
you
wish
as
you the
well.
best of luck.
Although not as Pitbull today, not like last time.
Well, you and I had a discussion earlier, so that's why I went a little more nicer. So, Pepper, the reference Pitbull is so last time when we had the McDaniels v. Reagan, I was talking to Longshade about something I discovered, and he goes, "You know, Miss McDaniels, you're like a pit bull." I'm like, "What?" He goes, "Yeah, in court you're like a pit bull. You're not very nice to the new ones, are you?" I'm like, "No, not really. It's not my problem, if they don't know something." Because I'm not going to bring it up, but basically, I was called a pit bull by Longstreet, and then this one over here, Wolfgang, he goes, "Yeah, I call her grab him by the balls, McDaniels." Uh,
Yeah.
I'm a marshal's worst nightmare, essentially.
Hans and White and all of them got a
Yes.
special liking to you.
Yeah. They have an affinity. They have a hard on, I'll say, is basically what it is.
Oh my goodness.
Well, I definitely look forward to seeing you again, and hopefully, maybe there might be something we could work together on in the future.
Wonderful. I would like that. Yeah, come on down to the candy store. I'll show you the firm. Actually, our firm is literally right above the candy store. Um, the contractor who we hired did an amazing job. Unfortunately, my outdoor patio furniture I had in Rhodes couldn't be transported. I guess there was an issue with finding a wagon big enough for everything. So
Ah,
it's simply just interior at this point. Maybe one day I'll have some picnic stuff again. So
okay. All right, and Mr. Rugart, I hope you don't take any of this trial personally. It's
Oh,
So-
no, I never do.
Yes.
No.
yeah, we know how it is. You do the best that we can for our clients, and just try and get them the best
Who's the
outcome they can
individual
get.
again?
Yeah, no, I definitely understand. Like I said, it is not. It is no hard feelings. You know what I mean?
Yeah, I tell you, working defense cases all
He wants
often
to
scares
drop
me.
those charges.
Because
Oh yeah.
I mean, you just think about it. You defend one person, you make an enemy of another, and then it gets kind of iffy when you think about it.
Yeah, no, I definitely understand. I definitely know what you mean.
Attempted murder. And who is it attempted murder of?
All right. Well, I'm gonna get back over to the forge.
Oh, gotcha.
It was
All right. Well, let's
pleasure
talk to
seeing
him
y'all
here in
again.
a second
And
and see if we
again,
can
I hope
figure
to
out
work
what the
with y'all in the
exact date
future
is.
on something.
If Hans is going to drop the charges, then
No, you're fine. Be
there's no
careful out
case
there, my
against
man.
him. There won't be anything that reflects
Y'all
his
be safe
record.
out there.
Come
Any
up,
record that he has
come
will
up to
be
West Elizabeth whenever that,
expunged as far
brewery
as those
opens,
charges
you know
are
what I mean?
regarded. If they're
Oh,
somewhere,
I'll definitely be
where they can
over there
read
for that.
way.
Where's it?
Yeah,
If charges
there
are
you
dropped,
go.
then he's effectively
Where's it gonna
never
be?
committed the crime.
It's in Blackwater.
Okay. Yeah, I'll definitely swing by.
Yeah.
I come over there quite frequently to bring Dottie some herbs, and I'm actually about to bring Pete some creeping time because he's really neat.
Yeah, and if
Yeah,
you'd
if you ever
like,
get American ginseng,
you
let
could
me know,
write
'cause
up
I've been
a letter
buying
of
it.
expungement,
Oh,
and then we could just expunge the
I
record.
don't
if
have any
Hans-
on me,
if
but
Hans
I
pressed
have
these
a
forever ago
stack
and is
of it
now
in
wanting to
Rhodes,
drop
like
them. If
32
you
of
could get
them.
a telegram from
Yeah,
Hans just
I'll
saying
have to pick it up from you sometime.
that he's
Okay.
turned a new leaf. We've
If
decided
you ever
we
need
don't
to
want
reach me,
charges
you can always
pressed,
telegram me at Felix.
and that we would
Yeah,
request
I
that
got
his
Felix.
record be expunged.
Mhm.
And then you write up
I
an
got you.
expungement
I'll
letter as
definitely
the
be sending a
attorney that
telegram
just
here to
basically
you.
says he's done X things. He's a good member of society. And then
All
I will
right, I'm gonna
consider
get back
removing
over
the record.
to Rhodes. Y'all be
And then-
safe and safe travels.
Sounds
Yes,
good. Be
exactly.
careful out
Yeah,
there.
I will consider it that way just because the charges would effectively have been dropped. And then in addition to
So this has definitely been interesting. So the role play between this situation, you're talking about lawyers going after lawyers in this situation. Essentially, you're a lawyer who's the opposing counsel, and the other is a lawyer defending a paralegal, and that client is one of their firm members. So it's interesting to kind of see the dynamic whenever you enter litigations like this and see how the opposing counsel kind of reacts afterwards. If there's kind of a respectful interaction or if they're hostile. You know, it's good to see that nobody's really taking it personal. You know, it's just this is what we do for work. It's nice to see that actually. You know, there's not a win mentality there. There's, you know, we both gave it our all, and I don't have. Okay, so we're doing this. $1. Here we go. 9. I hate when that happens. Here we go. Wait, do I have American ginseng in here? Burrow, oleander. No. Oh wait. Come on, that's oleander. But yeah, it's definitely been an interesting trial and my first litigation by myself. So, yeah. And of course, my horse don't work. It's interesting whenever you go to court because, as he was stating at the end there, you know, you come across this situation where, you know, we can kind of account for time that was missed by Mr. Pierce, you know, due to having to reach out to counsel and stuff like that. But there's no like factual evidence of it, so he can't necessarily rule that that's something that should be given. Horse is already at the stables. Of course it is. Or already out the stables. But again, this has been very interesting. I wish I had streamed whenever we went up against Miss McDaniels, because man, was she vicious. She was vicious, and I pissed her off.
Yeah.
There was
I mean,
a
I'm
statement I
still
made
okay,
that
like,
that
together.
sent her over
You
the
do
edge,
look very
and it was
menacing. That's
actually
what I'm trying to go
um,
for.
No,
it was
not
interesting
really,
to witness afterwards,
You look like you would try to rob somebody, but
but... Oh no, don't want to do that.
or to talk about rather, because it was
Oh hey, Phoenix.
howdy,
it's not bad. I've definitely seen a lot worse.
but it was without a doubt, it was very interesting to see that situation and be a part of it. I had just kind of been along for the ride with that one because Schimmel had taken on the case, and he basically prepared everything. I basically came on the case like last minute and just helped where I could. And apparently the help was pissing off Miss McDaniels, which worked very effectively. Although I'm glad to see that she didn't carry it out of that courtroom, because that would she might have been a little tense whenever I first showed up here today and was like, okay, well, this is that guy who made that statement. But I think our conversation up front, you know, it really helped kind of calm things down a bit, and you know, maybe lower tensions between each other. But overall, the role play of this was awesome. A lot of effort put in, a lot of just creativity about it. She had really good defenses. Here we go. Now it works. All right, Bacillus. Let's go. So one of the things that's interesting about the situation too, because both me and Huckabee were kind of curious of what kind of precedent this would set. It did set that there was malpractice in the situation because the client did retract their verbal contract of filling or of wanting the services to continue. So I showed in court that Mr. Rugart was negligent in informing Tom Smith of this recant of services, and so therefore he was negligent. In this situation, it's an interesting precedent because there was no guarantee of how long something would take. There was nothing in verbal writing or verbally said or in writing. Well, he did say a few days, so I guess that wasn't really taken into consideration. So they did take into consideration that the defendant had what's the word I'm looking for? They did have an exigent circumstance that did happen that caused a delay in the services being rendered, and so they didn't actually. That's also a bus. We're fine. So they did. They didn't make it so that in the future there would be like a time frame that would just be too much. It's going to be interesting if there is a case in the future where this happens again and there isn't an exigent circumstance. Hi there. Do you need a ride?
You know what? One would be fantastic. I'm trying to go
Alright.
to Rhodes.
That's where I'm headed.
Thank you.
Can't leave a lovely lady to be walking out on the road by herself.